think we'll start. So, hello everybody, and welcome to an op-ed talk from the Summer Institutes at the University of Washington. I'm Bruce Weir. I'm from the Department of Biostatistics at UW. And it's my very great pleasure today to introduce our speaker, Professor Erin Murphy. Erin is a law professor at New York University, training from Harvard University, law clerkships, work in public defender's office. And I've looked at Erin's writing over the last few years, but particularly on the implications of DNA typing and issues of privacy, and I find her writing and her thinking to be particularly helpful. And she's graciously agreed to talk a little bit more about today with a sort of an interesting title. So over to you, Erin, and thank you.
Go ahead, Erin.
I think you've turned it over to me, but I actually am having a hard time hearing you, so I'm not sure. Should I begin?
Just go ahead, Erin.
Yes, it looks like I'm ready to begin. Okay.
Sure.
Thank you very much. Hopefully everyone can hear me. If there's any technical difficulties, chime in and we'll get them sorted. My name is Erin Murphy. It's really nice to meet everyone virtually. As you heard, I'm a professor at NYU Law School, and I write a lot about forensics, including a book in 2015, which I've put up on the screen for my own self-promotion. As a lawyer who works in the area of forensics, I often find myself in these kind of interdisciplinary environments where I'm speaking to people who are in the biological sciences, or people on the statistical side, or people in my own legal community. And I think one of the most challenging aspects of the work that we do in the criminal justice system around forensics is its interdisciplinary nature. And so I wanted to talk to you all, who are obviously people with expertise and interest in statistical genetics, about how those skills or that information interfaces with my area, the legal system, and what cautionary tales and areas of pride we can have in that regard. So to begin, we all know, of course, that genetics and forensic genetics have done some amazing things for the criminal justice system. Most prominently, and I apologize, this image is a little fuzzy, but everyone at this point has heard about the large number of exonerations of wrongfully convicted people using DNA and forensic genetics. And that, I think, is a point of pride that everyone can take in the work in the field. But we also know that forensics have led to miscarriages of justice as well, that it's not just a happy tale. Now, the first DNA exonerations were studied very carefully to get an understanding of what contributed to those miscarriages of justice. And you'll see, of course, that eyewitness identification or misidentification, there's a typo, apologies, but the eyewitness misidentification was the number one leading cause that was found in cases. But closely behind, which is often surprising to people, was improper forensics. And that includes error, just mistakes that were made, as well as false and misleading testimony. And most famously, when we think about mistakes in the forensics field, we think about what I sometimes call first generation forensic methods, or kind of techniques like hair analysis or lead bullet or bite mark, or other kinds of kind of old school forensics. And it's easy to think, DNA is kind of exempt from that story. And I definitely think that forensic genetics, apart from being a rigorous science as compared to some of these older methods, is a science that by and large, when executed properly, performs well. But it's also important not to get carried away. We know from the early period of DNA testing that there were, in fact, wrongful convictions resulting from wrongful DNA attributions. There was, I think, kind of a quiet period, as it is. There's sort of a period of time after the DNA databases get started, when many samples are still large quantity single source samples, where people are learning a lot more about how to do the techniques properly and to present them in court, where I think we don't see wrongful convictions as much involving DNA. But I think we are at another watershed moment, or another sort of precipice, where we have to worry again about DNA's not just being, genetics not just being a source of accurate convictions and a source of exoneration, but also a potential source of wrongful conviction. And I could go on forever about that specific issue, but I want to talk about the legal system more generally, but I would just note that the reason I think we're in this moment now is because we have kind of acclimated ourselves to the idea of forensic genetics in the criminal justice system, but we also have more complex samples, more poor quality samples, more mixtures, obviously, as part of that complexity, and we have very sensitive instrumentation. And so the more sophisticated the instruments, the more difficult and challenging the samples as police officers go out and aggressively collect DNA because prosecutors expect it and fact finders expect it, the more we might worry again that the same kinds of problems that led to miscarriages of justice with other forensic methods are going to creep back in to the criminal justice system. So I want to talk a little bit about structurally why the criminal justice system is kind of poorly equipped for the type of science, and especially sophisticated science, that is presented by forensic genetics, and what we need to be on guard for, both as lawyers and as forensic analysts and others interested in the field. Now, I can't just talk about criminal justice without pausing to say we're obviously in a watershed moment of scrutiny in the criminal justice system, whether it's policing or prosecuting. This is a moment of transformational change, or at least analysis of the practices of criminal justice. But I'm going to focus specifically on forensics. So just to get started, we all hopefully know that we in the United States have an adversarial system of justice. So I thought we'd run a poll. If we can put the poll up, then we'll start there for everyone to participate in if they want. So you can see, you have to choose an answer for each of the 3 questions and then submit when you're done. I'll give you a minute to complete the poll, and then we'll look at the results and talk for a moment. Maybe just a minute more. Sandra, if you see there's a lot of responses, feel free to throw up the results. I think we're ready for the results if I can see them too. There we go. All right, so our questions. First, the prosecutor's ethical obligation. The majority of people got the right answer, which is to see that justice is done. I just will highlight us alongside the second question that the defense ethical obligation is to represent the defendant's interests. The overwhelming majority of people got that answer correct. Just to focus on these 2 questions, I think sometimes people think about an adversarial system and they think that the prosecutor and the defense lawyer have mirror roles, that they're both sort of one side versus the other side, and they represent, maybe the victim and the defendant, or the state and the defendant. But in fact, the quote from the Supreme Court on your screen and the ethical obligations of lawyers quote from below affirm that actually a prosecutor's job is more, first and foremost, to see that justice is done, which means truth-seeking typically. So it's not to win a conviction if in fact a conviction would not work justice. It's not to represent the victim's interest if the victim has an interest that is perceived to be either unjust or that perhaps is personal to the victim but isn't in fact best for the societal interest. The same thing with the people's will, although it's true that we think that the prosecutor is representing the people and they stand up usually and say, so-and-so on behalf of the people. The people's will might not be what justice demands. They're often, hopefully, fairly closely tied together, but in fact, the people may want to see a conviction in a very, emotional public case, but that may not be in fact justice in the case. So they may want to have leniency in a particular case, but for whatever reason, the prosecutor feels that the interests of maybe an unsympathetic victim requires that justice be done in a different way. And then conversely, the defense attorney's obligation is foremost to the defendant's interest, which means, in fact, contrary to a third of the answers here, the defense attorney's job is not to see that justice is done. That's the exclusive job of the prosecutor. The defense attorney has to work within the rules and structures of the law. This isn't an authorization for defendants to be unlawful or defense attorneys to act unlawfully, but their job is to essentially figure out how best to represent the interest of the defendant, which may or may not be justice seeking for the whole society. And the reason these are important roles to understand is because in an adversarial system, the only way the system works, if it does work, which I guess is another question, is when everyone stays in their lane and does their role. If a defense attorney decides my job is to do justice, so I don't really believe the defendant when they say they have an eyewitness, so I'm not going to go talk to them because I think this defendant's a liar. Or if the prosecutor decides my job is to get a conviction at all costs, even though I actually think this defendant may be not guilty, or there might be some evidence that exculpates them, the system breaks down. The predicate of an adversarial system is that the prosecutor is seeking the truth and the defense is representing the defendant's interest, which may be to hold the government to its proof, or it may be something else. Sometimes defendants have different interests. The last question is kind of a joke question, but I see that you answered it correctly in my view, which is that most lawyers are statistically illiterate. Now, I actually looked for a while to see if I could find an actual piece of, information from the, like some poll of attorneys how many were math majors or something like that, but I couldn't. But there is a passage in an article that I like that's about DNA, where the author goes through and cites a bunch of cases and actually has quotes, but they were too long to put in. But talks basically about how no American trial or appellate court seems to have correctly assessed the sort of question of the meaning of a DNA match in their opinions. So there's like a long list of cases where appellate courts, which are considered to be the kind of smartest, carefulest courts, are screwing up a basic statistical premise. I say that just because it's important in thinking about the sort of meat of what I want to talk about today, that we think about what system we're walking into when we're thinking about statistics in the DNA and in the DNA realm. And I see about a question, what about improper methods calculated to bring about a just conviction? Yeah, well, that also, if conviction is just, but the method that was used to calculate the conviction is wrong, that to me is analogous to the sort of, can I lie under oath if I think I'm serving justice? Because the creation of the false evidence serves what I think of as the ultimate goal of justice. And I would say the answer to that is no, because that basically makes one person the fact finder. I did a fact finding. I know what's just and unjust, or I know what's true or false. And then I decided to create or manufacture evidence or use what I know to be faulty evidence in order to promote my conclusion. And our system isn't set up that way. Our system is set up as an adversarial system, which is to say, within the bounds of the law, you present the evidence, and if the evidence shows guilt beyond a reasonable doubt, a fact finder convicts the person. And that if any one person, whether prosecutor or defense, takes it upon themselves to decide when to break the rules in order to create a just outcome, it's kind of fair game. I think that subverts our system, actually, and it actually ties into one of the things I think we've seen, which I'll talk about in a minute, about how wrongful convictions come about. So that's the ideal of our system, this adversarial process, two sides going at it, everyone's equipped, and we have a lot of imagery for that idea of a system. But the reality of our system, I think, is quite different, and it's important to understand the reality in order to appreciate the pressures, I think, on many forensic analysts and how to think about doing a job as a forensic analyst in a way that honors the ideals of the system while also works within the reality of the system. So I want to talk about 4 features of the sort of overburdened system. I don't have much time, so I'm going to go through them quickly. The first is, of course, that we have a highly overburdened, highly congested system. Most of that is low-level cases, many of which don't involve forensics and certainly unlikely to involve DNA. Or genetics of any kind. But the reason why an overburdened system, even when it's overburdened by misdemeanor or low-level cases, is important to understanding the system generally, is that, for instance, when it comes to prosecutors, most prosecutors are not going to have time to carefully read reports. They're going to have to skim reports. They might skim them on the eve of what they didn't think was going to be a trial, but turns out to be a trial, or skim them quickly right before offering a plea bargain at a hearing. They will rely heavily on what the forensic analyst says, because they will not be able to carefully, have a 3-hour conversation with that person or ask them in depth about the case, especially if it's a case they didn't anticipate going to trial. They may not actually give the analyst adequate time to do the testing, because they'll call and they'll say, I have to have this tomorrow. And the analyst will say, well, I have like 1 million cases in front of that. And the prosecutor will say, well, if it's not ready tomorrow, they're going to throw the case out, and it'll put a lot of pressure on the analyst to complete the analysis. And they're not going to have a lot of time to prep a witness, which means if you are the analyst, you often are coming into court and getting a 20-minute quick in the back room primer on, here's what I'm going to ask you, does that sound good? As opposed to a careful sit down, let's talk back and forth and think about how best to present this to a jury. So it places a lot of pressure on an analyst to perform without a lot of assistance in doing so. The next thing about overburdened systems is, of course, there's also a big problem of the adequacy of defense counsel. And this is a problem in many jurisdictions, I almost would say all. It's a problem of quality of counsel. It's also a problem of access to resources like experts and so forth. And it means that defense counsel, like prosecutors, are going to be often relying on the reports that were written. They're going to be speed reading, and they will not have access to independent expertise or someone to ask more questions, which means as an analyst, they may need the government help explaining that to them, even basic things. And they're going to need to trust that the government can give an accurate answer rather than a biased answer, an answer that promotes one view of the case. They're going to need a fair broker in the government's analysts, in essence. There's also a problem of problematic legal standards when it comes to forensics, which is to say, and I could tick through a bunch, I see I'm practically out of time, but we have very rigid rules in many jurisdictions about discovery, what information the defense may receive. There's no constitutional right to receive even basic information prior to taking a plea bargain. So in most jurisdictions, for instance, if someone was accused of rape, they don't even have a constitutional right to find out, well, was there a rape kit done? Has that been tested? Could I see the results of that test before I decide whether to take a plea or not? And you might think, well, this is fine because people won't plead guilty to crimes that they didn't commit. But we also have procedural rules that incentivize taking a plea, even when it's an innocent person. And in fact, you saw the earlier slide that many of the wrongful convictions were people who did in fact plea. There's also no right necessarily to discovery of information just to promote a defense theory of the case, as opposed to challenging the government's theory of the case. There's no right for the defense to have access to databases or run database searches or have access to the evidence outside of a specific case, like to see if perhaps structurally there's something wrong in the lab. There's also a problem of how we receive evidence. Even if a case goes to trial, we receive evidence in this kind of Q&A format with no room for often jurors to ask questions or for there to be a dialogue. We have this sort of adversarial model where the questions aren't going to necessarily flow in a logical way. They're going to flow in a way that helps the party who's asking them. So all of these things together conspire, I would say, to distort the difficulties of a scientific enterprise and also distort the findings. It makes it much harder for any particular analyst to just kind of come in and be a scientist. They are immediately put on the box as a partisan. You are the government's expert. And then they're kind of asked questions in this adversarial mode that makes it difficult to present the information in a complete way that's intelligible to the jury and that is actually something a jury could understand intuitively and not just rely on a prosecutor for, or rely on the conclusions for. And then last, of course, is the problem of human bias. And we see this thoroughly throughout forensics. We also see it in the legal profession, cognitive biases, confirmation biases that lead people to think that the results that they got are sort of foreordained, or that they have to be reliable even when they were in fact tainted by earlier implicit assumptions, subconscious assumptions, not necessarily malfeasance. So just to wrap up, since I'm running out of time, I'll note that there's a whole slew of best practices out there, how to kind of ward against some of these problems, and especially a lot of expertise on cognitive bias these days. I will note also that some of these things are more dangerous in some people than others, right? There's a way in which, if your role is to promote your client's interest above all, as long as you're doing that within the confines of the law, a cognitive bias may not be as bad of a thing as if your role is to seek truth or seek justice, in which case you might be blinding yourself to external factors. In some ways, if a defense lawyer is so, biased, my client has to be innocent, for instance, the consequence is likely to be that they get caught when there's evidence on the other side because they haven't really thought carefully, like, well, how could you interpret that evidence against me? And so an injustice isn't necessarily done. Conversely, if you're a prosecutor, though, and your job is to prove guilt beyond a reasonable doubt, and instead you are sort of pushing the evidence away that suggests somebody is not guilty, the possibility of an injustice is greater. And so I think there's a really important point to be made about the roles that people play and how that could infect the process and the integrity of the process. So I think in the end of analysis, especially for forensic analysts, there are 4 principles that are in some ways I think, key guiding principles that all analysts should take to heart. One is the basic neutrality of their position, that in essence, an analyst is to be a scientist, not to promote a particular theory of the case or to promote a particular view of the case. They should be able to present the evidence with a neutrality and a fairness, and allow the fact finder, whose job it is to decide what the evidence in toto says, to draw their own conclusions. Second is transparency. As a scientist, it shouldn't be necessary to hide the information, hide the decision-making processes, hide the testing processes. Third is clarity, and this is really important because lawyers don't speak science very well, and jurors definitely don't speak science very well. And so writing reports that are clear, that don't hide the ball, that don't require reading between the lines, et cetera, that are very straightforward about what is known, what is unknown, what was assumed, what was proven, is important. And lastly, and this one's I think a tricky one, is certainty, not experimentalism. Prosecutors will always be trying to get the evidence that they can get. It's often going to be up to the scientist to say, we're pushing beyond what I can say with confidence and certainty. And it's often, scientists are often interested in pushing the envelope. They want to try the new thing or promote the new theory. And it's important that the scientists be able to say, it only goes this far and no farther. Because the prosecutor may not know, even if the prosecutor is trying to stay within the boundaries, they may not know they've asked to push into something experimental. And that's something that can be great for journal papers, but not great when you're dealing with people's liberty and lives. So those are my sort of op-ed thoughts on forensic point, but thank you all very much.
Thank you, Erin. That was.
I still can't hear you, Bruce. I don't know why. I'm not hearing you. Oh, here you go. I got it.
Okay, so thank you. That was wonderful. It's exactly what I was hoping you would do. And we have this recorded so we can enjoy it at our leisure later on. So we have run out of time. I see other urgent questions in the chat room. I think thank you. I think thanks. So our audience was sharing my views. So thank you again, and we'll say goodbye to everybody. Bye-bye.